Hey, Joe Zarzaur here to talk to you about mediation in the personal injury process. First of all, I think unless you're a lawyer or you've been through a case, a civil lawsuit, you probably don't know what the word mediation even means in the context of a personal injury case. But let me put it into context for you. Way back in the olden days, before I was practicing law, so 30 plus years ago, you filed a lawsuit and you basically fought with the other side until it was time for the trial. And then you went to the courthouse, and the first time you ever even saw the other party again and the lawyer together was on the courthouse steps or in the courtroom as you're picking a jury. And if you had the occasion to talk to the other side, of course, nobody wants to talk. Nobody wants to be the first person to bring up settlement because it seems like a weak stance or a weak position to be the first one to bring up settlement. Most cases went to trial because people didn't want to broach the topic of settlement because they didn't want to indicate to the other side that they had any weakness, right? So a lot of cases didn't get resolved. The courts began to think maybe we should break the ice and make it to where the parties don't bring up settlement, but the court does. If the court brings up the possibility of settlement, then neither party has to bring it up first. And if both parties are forced to go and try to see if they can settle a case before they go to trial, then maybe cases will go away. Well, about 30 years ago, courts started adopting mandatory mediation requirements in every lawsuit. And now, virtually every judge has, before they'll give you a trial date, they require that you go and mediate. Now, what does that look like and what does that really mean in the context of a lawsuit, personal injury lawsuit? Well, here's what that means. After you've filed a lawsuit, so this means you're the small percent of cases that even required a lawsuit. Last time I checked, it was around 5% of Florida cases actually don't even get to the courthouse with a lawsuit. But let's say your case doesn't settle, and it's one of the 5% or 10% here that actually go to court, i.e. there's actually a physical lawsuit filed. If you're one of the small percent of cases that actually goes to court and there's a lawsuit filed, you will get an order from the judge at some point in the case before trial that says you have to sit down with the other party usually at a lawyer's office that's called a mediator. That lawyer has to be certified as a mediator, and the mediator is more like a referee, and he or she will basically, their job would be to try to figure out if there's any room to settle the case. And you will go to this mediator's office. Most of the time it's at the mediator's office. And then it'll be you and your lawyer and the person you're suing and their lawyer. And then usually an insurance company representative is there because at the end of the day, in most of these cases, an insurance company is paying unless it's a products liability case where you're suing the manufacturer of the product. But even in those cases, there's usually somebody that holds the money for the client that usually shows up. And what the mediator will do is the mediator will first get everybody in one room and they'll say, okay, what's everybody's position on this? And we as the plaintiffs of the injured person go first, and we tell the entire room, including the referee, the mediator, and the other side, why we think our case is worth a lot more than they're thinking the case is worth, the other side. And then we'll stop talking, and then the defense or the other side of the case, their lawyer will stand up and their lawyer will say why he or she thinks our case is not as valuable as we think it is. And then he'll sit down. There's no role for either. Our clients don't speak at this. Their clients typically don't speak at this. But the one thing it adds is our client, for the very first time in the case, gets to see it with their own eyes and ears and hear the other lawyer's position. And vice versa. We get to look right at the other party instead of the lawyer, because we deal with the lawyer in the case, but this is an opportunity for us to look dead in the eye of the person that we're going after, or the insurance company, or both, and say, you need to pay this much money, or this case is going to cost you a lot more if we go to court. It gives us that opportunity. After that opening session, I'll call it a joint session, is over. That takes about an hour and a half, 2 hours. We then split off into separate rooms. The plaintiff and his client will go in one room, or her client will go in one room, and then the defendant and her client will go into a different room, or his client. And they will be in separate rooms the rest of the mediation process. And the only person that's going between the rooms is the mediator. And the mediator will basically come in our room first and say, okay, Joe, you think your case is worth $1 million. They think your case is worth $200,000. Tell me why you think your case, I know you just told them why, but tell me why with specifics, why you think it's worth closer to $1 million than $200,000. And then we start telling the mediator how he's going to go in there and try to get more money. The mediator will be going back and forth to the rooms, basically trying to broker a deal, trying to figure out if there's common ground between our position and their position. And if there is, let's say the case can settle somewhere in the middle, right? Let's say it can settle for $600,000. Well, the mediator will start looking to see if that's possible. And then at the end of the mediation, the mediator will come back and say, look, this is what they're willing to offer. Is this something you're willing to take? And sometimes it works out, sometimes it doesn't. The rate is around 45% success rate. So most of the time it doesn't. But most of the time, not 100% of the time, you leave there knowing, okay, this is what they think the case is worth at this point, right? And at least you as the client know at that point in time where the other side is thinking from a value perspective the case is. So mediation does help in that it breaks the ice that used to exist between parties because neither party wanted to be the first one to bring up settlement. This forces us to talk about it and forces us to see whether or not we can settle the case. Many times, or I shouldn't say sometimes, I guess a minority of the time, both we as the plaintiff are thinking the case should settle for a number, they are thinking the case should settle for a number, and I guess in some of the occasions, it settles. So in those 40% times that I've said we're successful, that's when both us and the other side have basically agreed that this is what the case is worth. And the mediator says this, a lot of mediators say this, you're not going to go to a mediation and leave thinking, wow, I really stuck it to him. That's what you do at a jury trial, right? You leave thinking when you win big, boom, I stuck it to him. At a mediation, you leave and you think, well, that wasn't really everything I wanted, but I guess that's a reasonable settlement. So, and then they leave thinking, well, heck, I didn't really want to pay that much to that lawyer and that client, but it's probably a good deal for my client. So it's a thing where you work it out. Neither party's going to go out and necessarily celebrate, like bring down the rafter kind of celebration, but you're going to go out and maybe have, a toast, like I'm glad this is over and we're happy it's done. Mediation allows for closure. It allows for an expedited into the litigation, and it avoids, many clients don't want to go to trial. Lawyers like me want to go to trial all the time, but that's not exactly always in the best interest of the client. So mediation is a positive thing for our system. It clears the court's dockets of cases that can be resolved. We don't have to burden jurors with cases that could be resolved. And then that means that the only cases that end up going to trial are the ones that could not be settled, and we tried. So if you have questions about your personal injury case, whether it's a car wreck or some kind of medical malpractice or products liability case where somebody is injured severely, you can find us on the web at zarzaurlaw.com, or you can call us at 855-HIRE-JOE. Thank you.